Hello and welcome to Lawfully Creative, the podcast where we explore the intersection of law, creativity, media, and technology. I'm Annabelle Caperti, entertainment and media lawyer and founder of Crefovi. And today we are going to talk about a topic that has quietly become one of the biggest legal issues facing digital creators. Accounts disappearing. More specifically, Instagram and Facebook accounts belonging to adult entertainers being disabled, restricted, or permanently removed by Meta. If you work in the adult entertainment industry, or even if you simply follow creators online, you've probably seen it happen. An account disappears overnight. Years of audience building vanish. Revenue drops immediately and massively. And when creators try to appeal, they encounter something that feels almost surreal. Silence. No explanation, no human response, no clear path to reinstatement. Today's episode is based on a long article we recently published on the two Crefovi websites, one version in French and one version in English, crefovi.fr and crefovi.com. This article is titled Meta versus Adult Entertainers, Why Instagram and Facebook Accounts Get Taken Down and How to Fight Back. In this episode, I want to walk you through what is really happening behind these account removals, why adult entertainers are particularly affected, and most importantly, what legal tools actually work when a platform refuses to listen. Because the uncomfortable truth is this: when it comes to Meta, process, not politeness, is the battlefield. Okay, so the problem, what is going on? Let's begin with the basic question. Why do these account takedowns happen so often? If you look at Meta's public messaging, the answer seems straightforward. Platforms say they enforce community standards, particularly rules about nudity, sexual solicitation, copyright, and impersonation. In theory, those rules are supposed to create a safe and predictable environment. In practice, something very different happens. Across Instagram and Facebook, creators report a very similar sequence of events. An account is flagged, the platform takes action, a post disappears, or the account is restricted, or in some cases, the entire account is disabled. Then the creator tries to appeal, and that's where the process breaks down. Appeals are usually handled through automated forms. These forms generate automated acknowledgements. And after that, very often, nothing happens. Weeks pass, sometimes months. The account remains disabled, and the creator receives no meaningful explanation. Now, adult entertainers are particularly vulnerable to this enforcement loop. Why? Because their work sits right at the intersection of several ambiguous policy categories. Meta's policies include concepts like sexual solicitation or adult services promotion. But those categories are extremely broad and often vaguely defined. So lawful, consensual adult content that is perfectly legal in most jurisdictions, can still trigger automated enforcement systems. Another factor is monetization. Many adult entertainers use Instagram primarily as a marketing funnel. Their accounts direct followers to subscription platforms, websites, or other revenue channels. Think OnlyFans. From the perspective of automated moderation systems, that can increase an account's risk score. And when automation is involved, context disappears. An algorithm cannot distinguish very well between illegal activity adult artistic expression, or lawful promotion. It simply detects patterns, language patterns, emoji patterns, link patterns. And when the risk threshold is crossed, enforcement happens, often instantly. The result is not targeted moderation. It is what we might call blunt force moderation. Accounts are removed first. Questions, if any, come later. So what are the common triggers? When you analyze these cases carefully, several triggers appear again and again. The first is sexual solicitation signals. Certain words, emojis, or phrases may be interpreted by automated systems as invitations to paid sexual services, even when the account is simply promoting legal adult content or directing followers to legitimate subscription platforms. The second trigger is inconsistent enforcement of adult content policies. Two accounts may post very similar material. One remains live. The other receives a strike or suspension. Why? Because automated systems often flatten context. Artistic, personal, or promotional content may all look identical to a machine learning model. But perhaps the most troubling trigger we increasingly see is abuse of copyright law. Under US law, the Digital Millennium Copyright Act, or DMCA, creates a system called notice and takedown. The idea behind this system is reasonable. If someone posts copyrighted material without permission, right holders can send a notice asking the platform to remove it. However, in practice, the system is often misused. Third parties file copyright claims that are baseless or unsupported. They claim ownership of material they do not actually own, or they claim that copying has occurred when it clearly has not. Yet, because platforms process these notices at scale, they often treat them as presumptively valid. The burden then shifts to the creator. The creator must file a counter notice. The creator must prove the claim is wrong. And until the process is resolved, the account may remain suspended or disabled. So copyright law, which was designed to protect creators, can end up being used as a deplatforming tool. Finally, there is the issue of account takeovers. Creators sometimes lose access because their accounts are hacked or impersonated. Content is posted by someone else. Policies are violated by someone else, yet the platform's response is the same as if a creator committed the violation. Disable first, investigate later, if at all. The Colombian case. Now let's turn to a rare but extremely important example where a court intervened. In September 2025, the Colombian Constitutional Court ruled against Meta in a case involving the Instagram account of Esperanza Gomez, one of Colombia's most prominent adult entertainers. Unlike most disputes with platforms, which disappear into internal appeal systems, this case actually reached a constitutional court. And the court's reasoning is fascinating. The judges concluded that Meta's enforcement had been arbitrary. Instagram has closed the account without providing a clear and intelligible explanation. The platform referred to violation of its policies, but failed to explain how those policies had been applied. Even more importantly, the court pointed out that similar content remained online elsewhere on the platform. So the enforcement was inconsistent. The ruling did not simply criticize Meta, it went further. The court ordered the platform to improve its procedures. Users must be clearly informed of the reasons for moderation decisions, and they must have access to meaningful mechanisms to challenge those decisions. In other words, the court treated the absence of effective appeals not as a customer service issue, but as a constitutional problem. This case matters far beyond Colombia because it recognizes something many creators already know. An Instagram account can be both a livelihood and a form of expression. Disabling it without explanation can have serious economic and personal consequences, and that raises questions about due process. Just to clarify, the account of Ms. Gomez has been reinstated by Instagram since the handed down of the Constitutional Court's decision. So she's back online. Actually, she published a press release on her Instagram account, which URL link you can find on our articles on crefovi.com and crefovi.fr. So what are US tactics to deal with this systematic takedowns of adult entertainers' content on platforms such as Facebook or Instagram? Let's now look at the United States. In the US, reinstating a Meta account rarely happens through polite emails. Instead, pressure tends to come through legal and regulatory channels. One important development occurred in March 2024. A group of US state attorneys general sent a coordinated letter to Meta highlighting systemic failures in account recovery and user support. The letter described a surge in complaints about lockouts and suspensions. Users submitted forms, sent letters, filed complaints, and then waited months or sometimes years for responses. The attorneys general made one point very clearly: they refused to act as Meta's customer service department. This pressure matters because it establishes something important in legal disputes. When Meta fails to respond to users, that silence is not necessarily an isolated mistake. It may reflect a systemic defect in complaint handling. Another example comes from litigation involving adult performers. One case often cited is Vanguard and others versus Instagram. The lawsuit alleged that adult entertainers were effectively blacklisted on the platform through restrictions, removals, and visibility suppression. Now, this case did not produce a clean legal victory, but that does not mean it was unimportant. The pleadings reveal several key legal theories: systemic suppression rather than isolated moderation errors, economic harm caused by visibility loss, and the difficulty of proving intent when enforcement is automated. Finally, there is a more tactical approach that has emerged in the United States: small claim lawsuits. Some creators file low-value cases, not necessarily to win large damages, but simply to force engagement. Because once a lawsuit is filed, ignoring the issue becomes more expensive than responding. Journalists have described small claims course as a kind of informal customer service hotline for Meta. Not elegant, but sometimes effective. What are the European tactics? Europe now offers a somewhat different legal landscape. The most significant development is the Digital Services Act, often called the DSA. This regulation introduces new procedural rights for users dealing with platform moderation decisions. One particularly interesting mechanism is found in Article 21 of the DSA. It allows users to challenge moderation decisions through certified out-of-court dispute settlement bodies. These are independent organizations that review disputes between users and platforms. Now, Article 21 is not a magic button. It does not automatically restore an account, but it does something extremely valuable. It creates a written determination by an independent body. That determination can later be used in regulatory complaints or court proceedings. It also forces someone outside the platform to actually read the case. Beyond the DSA, national courts remain powerful tools. In France, for example, urgent interim proceedings can sometimes be used to challenge platform actions that cause immediate economic harm. Courts can impose daily penalties, known as astreinte, to compel compliance. In Germany, interim injunctions are sometimes used to force platforms to restore accounts quickly. However, timing is critical. If you file too early, before giving the platform time to review the case, courts may reject the request. In the United Kingdom, the situation is somewhat different. Since Brexit, the UK does not operate the DSA's dispute mechanisms, obviously. Instead, legal arguments tend to rely on private law principles, contract law, consumer law, or data protection, combined with reputational pressure. So what to do the day your account goes down? The instinct is often panic. Creators start emailing every meta address they can find. Press contacts, policy teams, investor relations, but the approach usually backfires. The most important steps in the first 24 to 72 hours are very practical. First, preserve the evidence. Take screenshots of a takedown notice. Record timestamps. Save emails and notifications because those records may disappear later. Second, download your data if you still have access. Posts, messages, activity logs, business records. Creators have lost years of content when accounts were disabled permanently. Third, identify the cause. Is the takedown related to policy enforcement, copyright claims, or a hacked account? Each scenario requires a different legal response. And finally, number 4, choose one escalation track. Do not scatter your efforts. Decide whether you are pursuing internal appeals, regulatory complaints, or legal action. Consistency strengthens credibility. So what is the real lesson from all of this? What is the meta lesson? It is not that Meta is uniquely malicious, and it is not that adult entertainers are asking for special treatment. The lesson is simpler. Process is the battlefield. Platforms operate at enormous scale. Automation drives moderation. And when something goes wrong, the default outcome is silence. Not necessarily because the claim lacks merit, but because the system was never designed to resolve it efficiently. Which means creators must approach takedowns differently. Treat them as legal events, not customer service issues. Document everything. Use the appropriate legal tools and escalate strategically. If you would like to explore this topic in more depth, you can read the full article on the Crefovi websites, crefovi.com and crefovi.fr, titled Meta versus Adult Entertainers, Why Instagram and Facebook Accounts Get Taken Down and How to Fight Back. Thank you for listening to Lawfully Creative, and until next time, stay creative and stay lawfully creative.